Welcome back to another episode of Litigious. I'm Scott Peterson. Reminder that this podcast is brought to you by Durazio Peterson, an employment and serious injury law firm in New York. If you have questions about that, please reach out to us. If you have questions about the show, hit us up on Instagram at Litigious Podcast. If you like the show, please follow, like, subscribe, and share with your friends. Giovanna is here as usual, and we got a full slate to cover here as we're nearing the end of the year. Um, We'll start today talking kind of a follow-up to the Sharon Brown firing at the University of Michigan. Just a background for anyone who doesn't know, Sharon Brown was the head coach of the University of Michigan's football team, and he was fired about a week and a half ago at this point after it came out very publicly that he had been involved in a relationship with a subordinate, which then escalated into criminal charges relating to the whole thing spiraling out of control when it became public, apparently. We talked about that last episode, but this week we're kind of focusing on the question of the day, which is kind of floating around the internet, which is, if he was involved with in an affair with a coworker or subordinate, how come they both were not fired? And there's a very specific answer to that, and we talked about that last time. You want to kind of touch on this briefly, or do you want me to cover sort of the policy that was at place here at the University of Michigan?
Yeah, you can cover the policy. I mean, I think the short answer is she was his subordinate.
Correct.
We talked about
So,
the last time.
yeah, so most companies have, and we talked about this before, most companies have in place policies related to intra-work relationships, and in particular, relationships relating to discrepancy between supervisor and subordinate employees. And that's exactly what Michigan had. And their policy came from a scandal only 5 years ago involving then University Provost Martin Filbert, who was at that point the second highest administrator at the school. So he's accused of sexually harassing multiple members of the university community, including employees and graduate students who worked in his lab, and engaged in multiple sexual relationships with subordinate employees, according to a report from a law firm that was hired to investigate it. Uh, Following and as a result of that incident or those incidents, the school implemented a policy governing supervisor-employee relationships at the university, and specifically stating that a supervisor may not, and this is a quote, implicitly or explicitly initiate or attempt to initiate an intimate relationship with a supervisee. That would be more starting a relationship with a subordinate. Uh, the policy goes on to require, and this is where really I think the rubber hit the road with him, that the supervisor was obligated to disclose the intimate relationship, and that the failure to disclose it was considered a serious offense and could lead to discipline. So I'll stop there and let you comment on it. I have some thoughts about whether, if this had been disclosed to the university in quiet, he actually would have been terminated. But why don't you comment on it first?
Yeah, well, I think also just in terms of her losing her job or not, my understanding is also that this was kind of a known thing, I think, that was going on. I mean, people might kind of like pretend that they didn't know about it or turn a blind eye to it, but I think that this was going on for a while and people knew. That being said, I think in the events leading up to him getting fired, my understanding is that she may have reported it. And now she's kind of protected sort of twofold because they also have an anti-retaliation provision as part of their don't fraternize with a subordinate policy. So if she goes in there and she reports a violation of the policy, then she's kind of protected as well from retaliation. Now, ordinarily, like you can't go and report something as a way to shield yourself when you are also the person violating it. But in this situation, she is kind of not really the main wrongdoer of violating the policy. So I feel like for her to go in and say, hey, this inappropriate thing has been going on, she is going to get a little bit of that sort of whistleblower type of protection. And I think, like you said, I mean, under normal circumstances or other circumstances, could they have disclosed something like this and either continued with the relationship in some way, or, maybe he could have quietly like negotiated himself out the door. But, obviously there's other stuff at play here. He's having an affair. He clearly had a complete meltdown. It's not normal behavior to like go to her house and threatened to kill her and himself. And, I have compassion for him if he's having a mental health crisis. On the flip side, are you having a mental health crisis because of your own actions that now you're having a hard time dealing with the consequences of in a rational way? Or do you have a genuine, mental health thing going on? I don't really know. You're cheating on your wife for 3 years with a subordinate. Are we supposed to now say, oh, it's because of your mental health? I have a hard time sometimes excusing stuff like that.
Well, some from our last podcast, we actually got some comments from people, and one of them, or multiple comments, were, these are two consenting adults. Why is this is a problem? Why is this a problem? Or to the original question, why wasn't she fired? And I just want to highlight, the policy did not require her to report the relationship. It required him as the person in the superior role within the organization, and that's a big point. That's an important point, and it's a very easy point for the university to use once this whole thing blew up, and to just say, "Hey, you violated the policy." And we see that all the time in employment lawsuits, which is, even if somebody arguably did some or was protected in some way, or was terminated in a way that they potentially shouldn't have been, if they violated a specific policy, it gives the employer a good faith reason, good faith I use in quotes, but a legitimate reason for making the decision. And that seems to be what happened here. And so it's probably a combination of she did not actually have an obligation under the policy to report it, A, and B, what you said, which is she does have some measure of protection because of any reporting that she made, and also because of the fact that she was the subordinate in the relationship. She could probably very easily say that, this was not necessarily something that I wanted to be involved with. And I'm not sure if that's the case, but from a university's liability standpoint, it makes sense, I think.
Yeah, and I know, sorry, I'm gonna like undermine your wishes for 1 second because I know you didn't really want to talk about the Coldplay thing again, but this does relate to it. So people may have seen today that the HR representative who was involved in that whole Coldplay, I wouldn't even call it a scandal because I don't even really feel like it was a big deal what they did. It was more that it just blew up so much on social media and just cr turned into like a monster. But they do talk about so she just came out with an interview kind of telling sort of not necessarily her, I guess a little bit of her side of the story of what actually happened, but also how negatively the reaction to it impacted her life. Because, look, everybody is complicit sort of in like taking a little bit of, entertainment value and like this kind of stuff blowing up. So to some extent, we're all complicit in that. But then there are the people who do things that are completely unhinged. So apparently this poor woman got like a million death threats afterwards, people like approaching her in public and saying horrible things to her while she was in front of her kids. Like she got death threats. That's crazy. Like that is totally, beyond the realm of like normal behavior. But anyway, going back to this thing with the fraternization policy, so they actually said in the article that she had been invited to return to her position, whereas the CEO was out. Now he resigned, but he probably was asked to resign.
Which
And
makes
she was
sense.
actually invited to come back and did not because she felt that she probably rightly so would have lost her credibility as an HR person by sort of exhibiting that error in judgment. And I think, look, who knows if this is true or not, or, how accurate it is. But apparently both of these people were legitimately like separated from their spouses and weren't really doing anything totally wrong, except that I found out that her ex-husband was actually also at the concert.
Oh, that's interesting. Well, I guess that's
So
not that
she said
surprising.
part of her reaction was that in the moment, she was like, oh my God, it's like you and I break up and somehow find ourselves at the same concert. And I'm like canoodling with my new, boyfriend or whatever, some flirtation. And all of a sudden I realize that like you can see me. I guess it's not totally outrageous that you would like try to hide or something. It's just that, clearly they did not handle that in the moment in a way that like you know, had any discretion or, whatever. But
Yeah, I think if I saw that, that might be the end of the podcast.
oh,
So,
you don't want to
you know,
continue the podcast with me, even if we
not at
get
that point.
divorced. That people,
Um,
more people would probably listen to it. That would be a good angle.
could be, yeah. Look, it's not uncommon for clients to, when something blows up, to want to respond or to get some kind of public exposure to try to counter a story that's maybe made the media or something like that. And her situation seems to me like a you should have probably let sleeping dogs lie. If you're
Yeah,
getting
I
death
don't think this
threats,
is getting a ton of good reception. The fact
yeah,
that
if
it came
you're,
out, like some of the stuff that I follow was like, not now.
yeah,
We got other stuff to worry about right now. We're done with this.
yeah, I wouldn't recommend somebody to do that if I was their attorney. I think the news cycles are so fast that you're better off just letting it go. I mean, nobody even remembers this anymore. So, all right, moving on. Moving on from that, there's an interesting lawsuit coming out of California against Uber and Lyft. This is reported by Forbes, where male Uber and Lyft drivers sued the company over a practice that they put in place, I think earlier this year, which allowed uh, riders to select women-only ride options. And so when they order an Uber, they have an opportunity to click women only. A group of male drivers have filed a class action lawsuit or suits alleging that these policies discriminate against men and reduce their earning potential. So, according to the reports, these policies were implemented by Uber and Lyft after years of harassment and assault allegations against the companies. And of note, this policy has actually recently been extended to teens, allowing them to select male or female drivers. And as parents of young kids, I don't necessarily have a problem with that piece of it. But so statistics, let's just look at some statistics here. Between 2021 and 2022, which is the most recent available data, Uber riders reported 2,717 incidents of sexual assault, which is roughly one case for every 700,000 trips. The most serious categories overwhelmingly involved women, with men accounting for only about 8% of the most severe incidents, and the numbers were similar with Lyft. 20% of Uber operators are women. Uber says this policy was requested by drivers and riders, and that since the implementation of the program, over 100 million trips have been taken. Um, so, what do we think about this? You want to get a little bit deeper into this. I think this is actually an interesting case. The argument for that the drivers are using, the male drivers, is Uber should not be giving people an option within its app to select women over men. It's the equivalent of giving them an option to select, for example, a white driver over a black driver, or a white driver over an Arab driver. Uh, they're saying it's essentially the same thing. And what they're arguing is that if Uber did not do this at all and simply allowed riders to choose their driver based upon the driving profile, for example, that they wouldn't have this problem. So, what do you think about it? It's actually an interesting legal case.
Yeah, I mean, in general, you can't discriminate against your employees on the basis of their sex. So I guess that's the argument that they're making, that this is sort of inherently discriminatory, any kind of rule or law or um, that uses sex as a criteria is going to be subject to some sort of scrutiny as to whether it's discriminatory or not. Um, I do think usually you can sometimes combat against a rule or law that differentiates on the basis of a protected status by having like a compelling reason why. And I'm assuming that that's going to be their argument here, that they have a compelling reason to allow women to choose women drivers because women have been disproportionately impacted by, sexual assault by male drivers. Um, I'm wondering if they could just get around this whole problem by just allowing everybody to choose, just having a way to choose gender, um, whether that's a male or a female. And then theoretically it would be equal. And if all the women are choosing women, and then that's just how it shakes out. Now I think you mentioned this when we were talking about it earlier, like there's a concept in the law about like disparate impact, where, a neutral policy, if it has the effect of harming only one group of people, that can still be discrimination. So, like, we see that sometimes in dress codes or rules about how somebody can wear their hair or not. It seems neutral on its face, but it's like, okay, well, only people of this specific religion are going to, violate this dress code, or only, Black people are going to have this issue with, this hairstyle that is being banned or whatever. So, it's a little dicey. I mean, I think I don't really know. I mean, the fact that people are saying it's impacting their ability to sort of earn a living, and they're actually going to lose customers because of it. I get what their argument is. I think, unfortunately, the fact of the matter is there are like a lot of there, like, sexual assault is like a really big problem in these ride sharing things. Like, even when you said statistically, like, maybe it doesn't seem like a lot when you say out of 700,000, but I guarantee you that it's more than that. First of all, I bet a lot of people don't report it. Um, and
Not to interrupt you, that actually seems like a pretty aggressive number to me. I mean, that seems like a lot because I'm sure there's millions of Uber rides a day. That would be my
yeah, that's
guess.
true.
So,
Yeah, and I know that I have, like, in some work that I do, have been privy to the fact that this is like a big problem, like to the point where I I would be hesitant to go in an Uber alone myself as a grown woman, and would not put my daughter in
all
one.
right.
Um,
For informationally, Uber, the estimates according to Google are that there are approximately 33 million trips per day. So when you look at it from that perspective, that's pretty frequent cases of assault.
yeah, so I mean, it's tough. It seems logical to me that you would be able to make that choice. At the flip side, I understand that there's plenty of men who, are not guilty of doing this type of thing, and would not ever do it, who, feel that they're kind of losing out. But in that, so taking it from, like, for example, like a constitutional law perspective, when you're figuring out, is a law legal or illegal, um, there's people might see this in the news. There's an equal rights amendment that they've been trying to get, that was ratified, that they're trying to get into the Constitution. There's a lot of stuff out there that would make sex sort of a protected status in the Constitution, which it is not right now. And because it is not in there, a law that discriminates against people on the basis of sex is only subject to like a certain level of legal scrutiny. Whereas when you made the, analogy to, could you choose someone based on their race, race is in the Constitution, so that receives like the highest level of scrutiny. So that would be, those two things are not necessarily sort of direct analogies.
Yeah.
So, it's possible. And some people have criticized the ERA because they have said that perhaps this will have an unintended consequence of being harmful to women, because it will not allow for laws that are intended to sort of protect women in some way. Because if you're using sex as a criteria, you're going to get subject to like the highest level of scrutiny. Whereas at what it is now, which is intermediate scrutiny, maybe they can come in and say, hey, like, we have a good enough reason to combat any sort of discrimination argument here, because we have a legitimate interest in protecting people from sexual assault.
Yeah. 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 I mean, I think that's reasonable. It seems to me that Uber could. avoid some of this if they had tighter screening um, methods for their drivers. Uh, and I'm sure it's like you said, unfortunately, these policies do impact all male drivers when I would imagine 90+% of them are perfectly good people who are just trying to, make some extra money or earn a living. And if my guess would be that if Uber put a little bit more effort into screening out the bad drivers, it would reduce these statistics and maybe make these types of policies less necessary. Um, but you know,
Yeah, but
uh,
and I think I was kind of thinking about it also in the sense of like, in New York State, the New York State human rights law prevents discrimination on the basis of sex, not only in employment, but also in places of public accommodation. So it's kind of thinking about, if you have like a private club or a private, there are situations where you can sort of segregate on the basis of sex. Um, but it is, I think even organizations like the ACLU or whatever have kind of acknowledged that this is a little bit of a dicey issue. Like there was, I don't think it's that prevalent anymore. I think it might have went under, but there used to be a women's co-working space called the Wing. It was sort of like WeWork, but only for women. And they were being investigated because it was like, well, is that discriminatory? Like, are you allowed to do that? Or do you fall under this sort of private club situation? I think the Uber is different. I would put into sort of its own category because you are alone with that person.
mhm.
Um, and they have the ability to literally like drive away with you. Um, so, especially as a woman, I do think that that puts you in kind of a different scenario than, the entire workplace or something like that, because you're kind of in an inherently vulnerable situation. Like women, at least this is the law in New York, like you're not really supposed to be, especially, in a vulnerable situation, like alone in a room with a male doctor. There's usually a nurse in there with you. So it's
Well, and that
like
protects
unheard
everyone.
of that you wouldn't have scenarios where there's a recognition that you're in a vulnerable situation. Um, you know.
Yeah, yeah. This case will be interesting. It's very early on, but we'll be following it because I think it's going to be an interesting assessment, and to see where it goes. Moving on to, well, another app-based lawsuit. A number of law firms have filed a lawsuit against the parent company that owns Hinge and Tinder after a Denver cardiologist was convicted of using the dating apps to find, drug, and sexually assault women over the span of several years. Now, this guy is serving a 158-year sentence, but the group claims that Hinge, again, which owns Tinder, um, ignored clear and longstanding warning signs that he was a predator. Of the six victims identified, five of them connected with him on Hinge and one connected on Tinder. All of them were drugged and sexually assaulted. So their claim is that Hinge began receiving complaints about him drugging and assaulting women back in September of 2020, and that although Hinge said that it was taking immediate steps to handle it and that it was banning him, 3 months later he was back on the app, and was they were again warned of the fact that he was there, and that although Hinge claimed that he had been permanently banned, he was able to make new accounts and remain on the app. According to the lawsuit, Hinge continued to welcome and promote him as a member, and it did not take additional steps to ban him, and in fact, through the algorithm, actually recommended him to some of the members. So he's active on these apps. This continues for approximately 3 years, during which he sexually assaults a number of women. And according to the lawsuit, at least, he was using the same name, photo, job description, phone numbers. Hinge did confirm that it had received the complaint from September of 2020 and that it banned him. But then apparently there's a recognition from their end that they did continue to recommend him through their algorithm. So this in our world, this is what you call notice. So why don't you talk about that?
Yeah, this is nasty. I mean, especially the fact that like you said, he was using the same photo and the same everything. So I thought this case was interesting because it has multiple different causes of action, and a
Yeah.
few of them are products liability. So I think like products liability is something that I think is going to be used as a tool to hold social media companies liable sort of moving forward, and maybe AI as well, because we don't really have sort of an equivalent. Like these are ultimately kind of products. So it's sort
It's
of,
yeah, it's technology.
yeah,
Yeah.
so it's an interesting kind of developing area of the law. People have used products liability against gun manufacturers also. But this is basically like a defective design, defective product lawsuit, failure to warn. Obviously they're alleging that there's something wrong with, their I guess what would you call it? Like their software. There's something wrong with their
Well,
product that would
it's their
allow
algorithm.
a banned, if you are banning someone, then they have to be actually be banned. So you're either, being disingenuous that you banned them, or there's something wrong with your product that you're allowing these banned people to slip through the cracks and remain on the platform. And I mean, I know nothing about how technology works, but I gotta assume that it's probably not the most difficult thing in the world to figure out if somebody's photograph is, being used multiple times. Um,
Y- Uh, yeah, I mean, I think there's a number of things they could have done. Like, there's certainly facial recognition technology that can identify the photo and pull it off. There's certainly the capability to ban the IP address, so you can't just create a new account from the same computer. This is the technology that social media platforms use to prevent kids who are under the age of whatever the age is, 13 or whatever it
right,
is
like if
for.
you get banned from
Yeah,
TikTok, you can't really get
exactly.
on there.
So, if in fact they had the data that there were complaints about him, which is what the plaintiffs are complaining, then they are on notice, which is the legal question is, from a strict negligence perspective, the question is, did you know or should you have known that this person was a risk? And did you act reasonably to prevent this person that you knew was a risk from creating additional harm? So I think the test is reasonableness in that case. And it seems to me that if you have this information and you don't take very significant steps to backdoor this to make sure it's not, or backstep it, I should say, to make sure that he's not using other ways to get in. I think this seems like a strong case to me. I don't know, I don't know the law in Colorado as it relates to this, but I think the product liability claim that you talked about is a very interesting way to get in on it. I honestly, I hope this case is successful because this is the kind of thing that these companies probably have the power to change and maybe won't until they get hit with a big verdict or a significant settlement that costs them and makes them change it.
Yeah, I wonder what the disclaimer. I have never been on a dating app.
Better not.
I was like, you better not. So
Podcast is
I
going
don't
sideways
know.
today.
Do you have to like sign 8 million waivers? Like, I just wonder,
I'm sure you do, but
it's clearly like a risk of you. I mean, this is probably going to be their defense, right? It's a risk of using a dating app that the person that you meet up with is like a creep and a rapist. But in this situation, like you said, they knew. The fact that they banned him kind of works both ways because it shows that they were on notice, and it shows that they perceived him as someone who should be banned and dangerous. And then the fact that they then allowed him to be on there. So I think that's where you kind of get the turning point of they're going to be liable for this. I think, same with the Uber. I don't think you're going to be on the hook necessarily, for these sexual assaults unless you have this extra step of notice, or something that you've done wrong in a background check. But I mean, a background check isn't even going to help you in a lot of these situations because I'm sure plenty of these predators out there have never been caught. So, doing a background check is not going to do anything. but yeah, I think, and we've talked about this in other podcasts about negligence and when you're sort of holding a third party accountable for something that somebody else did. You have to say, where is your duty to me? And I think in this situation, if you are going to host a platform and sort of invite people onto your platform, and represent it that it's safe, um, and it's completely foreseeable that if you do not adequately vet people or adequately take steps to ban people that are up to no good on there, then I think you probably have a good negligence case as well, aside from the product liability.
Yeah, I think it's very much similar to Uber being sued because a driver sexually assaults someone, in particular if they had noticed that this person was potentially dangerous or there had been prior complaints. And you can contrast that with claims that have not been able to be pursued against, social media platforms for content that they allow to be published on the platform, right? So their argument is always, well, we're just a platform. We're not publishing the content. We don't have any personal response or corporate responsibility for things that people say and do on these, on social media sites versus this, which is, I would assume they're going to maybe try to argue, hey, we're just the host here. We can't be responsible. But I think, I think there's a pretty clear distinction, and yeah, hopefully this help result in some changes because this is disgusting. I mean, uh, and I'm sure
Yeah,
this
and
is
I
not
think
the only situation.
sort of, I mean, we've probably talked about this in the past, how you kind of have multiple different ways to sort of achieve change when we have this sort of changing world with technology. And lawsuits are one way to try to make change, and then legislation would be another way. So I mean, ultimately I think there's going to have to be some laws, if they don't exist already, that require these platforms to take responsibility and not be able to say, oh, it's just a platform. I just open the door and then whatever happens happens and I have no responsibility. Because I think we see this come up even with First Amendment stuff, when people call the internet sort of the new town square. Like, we have to understand that the reality that we live in now is that people do things that they used to do in person on the internet. So if like if you own a hotel or something and your hotel is full of rapists and that, like, you're gonna be sued for something like that if that's happening like in person and about it and you're allowing it, to continue. So this is not really totally different from something like that. And I mean, we see that in our practice and just in general, sort of looking at cases in general. And anytime that you try to hold like a third party accountable, I mean, there's a lot of cases out there about people being assaulted, in a hospital or on a campus, or at a school. And you have to kind of show what the relationship is between all the parties before you can sort of pin it on the third party. But there's a ton of precedent out there for when you can and cannot do that. So I think it's just a matter now of, we're going to see the cases that are now going to apply it to these social media platforms.
Yeah, it's just an extension with new technology. Totally agree. Um, and we touched on AI earlier. We're gonna have an AI episode coming up because there's a lot to talk about from a legal standpoint and potential legal implications. So, okay, we'll do one last topic here. This impacts us as we have kids who are going to be hitting college age relatively soon. There is a proposed class action that has been filed against 32 colleges, and these are some of the most prestigious sort of primarily liberal arts, but not entirely colleges in the country, that argues that early decision admissions, which is an early decision for those who don't know, is an application option that ostensibly binds a prospective student to enroll if they receive an offer. It allows them to apply early, say, this is the school I want. And if they get in, they're in. And we'll talk about that in a second. And the allegation is that this process allows colleges to artificially decrease competition, charge higher tuition rates, and offer less financial aid. So this early decision process has been around apparently for a while, but it's come under recent scrutiny as critics are labeling it as a form of affirmative action for wealthy students who can afford to attend college even without any competitive financial aid offers. So the lawsuit claims that the colleges are participating in practices that entrench these patterns of inequality of access while at the same time inflating the price of attendance. And so they're saying that the students applying under these early admissions programs lose out on benefits of market competition. Uh, so they apply to one college, they get their offer. They believe that they're legally obligated to accept it, and they do so before seeing any financial aid package, which therefore they can't, there's no competition for financial aid. So I'll stop the discussion there and then we can get into it. The only thing I'll say is there's been a number of articles recently about whether early decision applications actually create any kind of a binding agreement. And from what my understanding of it is that colleges typically suggest to parents that they do in fact have a binding agreement, but in reality, legally there are often no contracts of any kind, and so the colleges can't actually enforce any kind of specific performance or force the student to attend or pay tuition, but they lead students to believe that they have to. So what do you think about this?
Yeah, I think it's interesting. So just as a little footnote to this, I sort of appreciated this was something that was coming up on my social media as well, because I think this article was sort of making the rounds. But I also appreciated that I had a friend kind of reach out to me and say, you guys should talk about this. So that's just a little side note to say that we appreciate it when people do that, and we will try
Yeah.
to respond and talk about this stuff when it comes our way. But yeah, so one of the videos that I saw about this that was sort of going around sort of brought you back to like first year of contracts in law school, which is when you learn about what's called consideration. And to have a binding agreement, you have to be getting something in return. So, one of the questions about whether these agreements are sort of binding in the first place is what is the student really getting in return in one of these early decision kind of agreements, because they're not guaranteeing admission, right? Like, what do you get in return? You're telling them,
Well, I
I'm gonna if you take me, I'm coming. What are you
well
getting
that
from them?
so this is really contracts 101. I don't want
Yeah,
to
this is
bore
like
bore
when
it
they,
too much, but so your offer is I'm offering to come here, and if they accept it, they're saying fine, we're accepting you.
now
Isn't
you have to
that's
come. What did you
now you
get?
have to come.
Right? Like you're
You
not
got acceptance into the
guaranteed,
school.
but you're not guaranteed that. Like, so what, you know what I mean? Like you're
Yeah.
committing yourself to something with nothing in return.
Yeah, I guess that's fair. Yeah, I mean, I guess that's fair.
So, and then I feel like when we were in like your first year of contracts, they do make a point to say that consideration can be very little. That's why most lay people probably see this when you have a contract for $1. You know, your
Yeah,
parents want to give you their house at the beach and they send it to you for $1.
yeah.
That's what consideration is. But yeah, I mean, I think it's interesting. So just in terms of whether it's binding, I mean, I'm not aware of, and I didn't see anything like this. I think the general consensus is that these are not quote unquote legally binding contracts in the sense that if you change your mind, the school is going to sue you for the tuition that you would have paid. That I don't think is what's happening here, but that doesn't mean that there aren't consequences because I just looked this up because I wanted to just double check it because I hadn't seen this, but I had heard about it anecdotally. So Tulane and perhaps other schools do this as well, has blacklisted high schools when one of their students has backed out of early decision contract. I don't know if they take that as being like your college counselors are trying to work the system and so we're going to punish the entire school. I mean, it's not beyond the realm of possibility that they could go and tell your other schools that you did this and you're not, a trustworthy student and that, nobody should accept you or I mean you have no control over if somebody decided to be vindictive against you on that. So I don't think that necessarily means there would be no consequences of this. It's probably if you did back out of something like this, I would say it's probably going to be one of the first times in a kid's life where they might find themselves having to have a very good explanation for something and having to explain it moving forward if it came up. Um, but yeah, I mean, I thought it was interesting though, because I never really thought about it this way, that it's a little bit of like a price gouging conspiracy, and then also really is just one of a gazillion examples of sort of the system, um, being skewed towards people with means, because it's really only people for whom college, money is no consideration to be able to lock themselves in without having any idea how much financial aid another college might offer them.
Yeah, I think the issue that people have with this is that the acceptance rates for early decision are significantly higher than regular admission. So I looked at this up. Um, University of North Carolina accepts 12.9% of early decision applicants, while they only accept 4.1% of general applicants. So what that tells you is that if you are willing to apply to North Carolina early decision and tell them basically, I'm going to pay full boat here, that you have a roughly 3 times greater chance of getting in. So if you are somebody who can't afford to do that, you're being disproportionately impacted by that policy. Now, that may or may not be illegal, because these are private, well, North Carolina is a state and a state school or a public university, I suppose. But so that may be part of it. But there's a lot of interesting questions here. I mean, as somebody who's starting to go through this process, you learn a few things along the way. Number one is that schools actually value uh, what they perceive to be interest in the school, and commitment to the school. So they place some inherent value on, early decision applicants because it shows that you actually really want to go there. That's the optimistic view of it. The cynical view of it is they see that they can lock in a certain amount of tuition, and so they have a vested interest in getting more students to come there. So, I sort of do see kind of both sides of this one. Um, I think it's interesting. The other piece of it, just going back to the enforcement ability. So let's say a student applies to a school early decision, then they back out. It seems to me that it would be foolish for a school to sue somebody on that, even if they had the ability to do it, because, yeah, you might set a precedent and it might scare people, but I suspect it would also decrease the number of people that apply for early decision if they thought that that was actually the case. Counter argument to that is if people think there's no teeth to early decision, then theoretically you could just apply early decision with no real expectation that you're going to go just to see if you get in. So I think there's like a number of angles on this one, and I'm sort of interested to see what happens with this lawsuit. I assume there'll be some settlement or resolution that maybe modifies the early decision process at some of these schools. That would be my guess,
Well, it
but
said also
yeah.
that it says here, okay, so it says also named as a defendant in what the complaint describes as an early decision conspiracy is the Consortium on Financing Higher Education, an organization of highly selective colleges that share information on admissions and financial aid. And then they have also the common application to college admissions platforms used by the schools. So I think, they're also basically saying that they're using kind of this system to probably try to figure out how to pay as little aid as possible, because apparently as part of these agreements, you're saying not only am I going to come, but I'm accepting whatever financial aid package you give me. So they don't have any, and my understanding is that this is also kind of a separate process from like applying for scholarships. So it is sort of, you know, that also makes sense in this with this argument that it's disadvantaging, lower income people, because you may not have the means to exist sort of outside of applying for scholarships and just say, okay, I'm just
For
going to
financial aid.
take.
Yeah, yeah. Yeah, it's interesting case and very relevant to us in our current state of raising kids.
Yeah, I mean, look, I think what you said earlier is the most sort of compelling thing to me, that it's like that creates sort of an unfair situation, is that if their rate of acceptance is so much higher for early decision, but it's financially unfeasible for a lot of people to do that, then that does seem like a problem that should be, fixed in some way. That being said, I mean, I don't think there's any such thing as discriminating against people on the basis of their income status, but these could be like disparate impact types of situations. And then also if it's like a price fixing conspiracy, and then I think that's what they're alleging, then that's kind of a different thing.
I think that's probably a more compelling legal argument than a discrimination argument. I think it seems to me that that's probably stronger, so that's probably what they would focus on. Um, yeah, eh, who knows? We'll see what happens here.
It's hard because
Um,
you're also making this commitment so far ahead of time. I mean, I think you and I are both like, not that we're like non-committal people, but I think we like, some people you like to have your options open, and then once you commit, you're committed. But like, you're asking kids to commit to something like well over a year probably, or, before it's a reality, and things can change, and it's tough. I mean, I get it. I mean, if it's going to improve your chances to get into the school that significantly, then I can certainly see the appeal.
yeah, but you lose leverage, right? We negotiate for a living, and so you know, you'd never want to be the person going into the negotiation saying, I'm so interested in getting this case resolved that I'll take whatever you can give me. The person with the most leverage is the one who's willing to walk away. And so if you're considering, college applications in some way or financial aid is something of a negotiation, which my understanding is it is to some degree, you know, I, I think you'd want to be in a position if you can to be able to say, I might go here, but if you don't offer me enough, I might go there, and then let the colleges
But this
negotiate.
may be, I mean, I agree with that part of it, but at the very start of what you said, I mean, this could be one of the few situations where that's not quite true, because you also have at play that they want their like admission, like their, I don't know what the proper term for it is, but like you said this earlier about they want to know that you're interested,
Yeah,
because they want to
yeah,
show the how selective they are. So they want to be like, we're only, offering this many slots to people, and they're all accepting them. So that's like, then their acceptance rate is, so for them, they do have an interest in people applying early decision and knowing that they're
yeah. That's fair.
locked in, because then they don't have to put offers out into the universe that kids are not going to accept.
Yeah, that's fair.
I don't
We'll
know.
have
I
a lot
was
more
kind of
information about
hoping,
this over the next couple of years.
yeah, I was kind of hoping the entire system would collapse before our kids had to go to school.
You mean the cost structure?
Like just everything, like the whole thing,
Yeah.
whole
No,
thing.
I don't think that's going to happen. All right. Anything else on this before we wrap?
Um, I don't think so. I think that was it. I shoehorned the Coldplay thing in there
I
earlier, so.
noticed. Yeah. All right. Well, we'll wrap for today. We're going to do a year-end episode next week, and then we will roll right into 26 with some good, interesting topics on the horizon. And I'm sure an inevitable significant number of legal cases in the news. So, as always, thank you for listening. If you have questions, hit us up at Litigious Podcast on Instagram, and feel free, please, to like, subscribe, and share. We will talk with you again soon.